my name is Nur Ashiki Binti Abdul Aziz and my metric number is 261152. So today I'm going to represent my client Amran Fana for the charge of consuming drugs under Section 15 Subsection 1A of Dangerous Act 1952. The first issue is in regard to the accused urine specimen examination, which did not comply with the requirements of Section 31A of the Dangerous Drug Act 1952. In this case, SP2 had received an order from SP1 to conduct preliminary screening of the accused urine on 5 June 2021 at 8 p.m. At that time of the preliminary screening are conducted, SP2 hold the positions of Lance Corporal in Chitra Police Station. SP2 informed the court that he had instructed accused to sign a consent form to give a urine sample, choose an empty bottle and fill the bottle with the accused urine inside the toilet and return the bottle to SP2. Once the accused handed the urine bottle to SP2, SP2 carried out the preliminary screening by using a urine test strip provided by the department. SP2 then labelled and sealed the bottle and passed it to SP4, who are the officers appointed to investigate the case. So the contention that I would raise is according to Section 31A of the Dangerous Drug Act 1952, which provide that a police officer below than the rank of sergeant or a custom officer is not allowed to require an arrested person to provide such a sample of his urine to the police officer for the purposes of a test. This provision had clearly mentioned that police officer below than the rank of sergeant or a custom officer is not allowed to do a test on an arrested person. However, the preliminary screening test of my client, the accused, was conducted by SP2, who was at that time a Lance Corporal, which the rank is below than a sergeant or a custom officer. This act had clearly proved that the screening test was unlawful and evidence was illegally obtained by the officer. Your Honour, please refer to the case of Aizuddin Shah bin Ahmad vs. PP, where in this case, it is already held by the court that the provisions of criminal statute must be strictly followed and that the failure of which would amount to breach of rule of law. This was a fit and proper case for the urine sample to be excluded and or expunged from the evidence. Your Honour may also refer to the case of Public Prosecutor vs. Hamilton Robert Tingon, which provide about the test conducted by the police officer who is not above the rank of sergeant and how the court had found that there is breach of Section 31A of the Dangerous Drug Act 1952. By referring to the case and provision I mentioned, the urine sample shall not be admissible by the court as it had failed to comply with Section 31A of the Dangerous Drug Act 1952. Therefore, I would like to seek an order from Your Honour that the examination process of urine sample is illegally obtained and unlawful and that the urine sample of the accused shall be excluded and or expunged from being admissible as evidence. The second issue that I would like to contend is the differences between preliminary screening tests and pathology reports. On 5 June 2021 at 8 p.m, the accused was found positive for methamphetamine after undergoing the preliminary screening by SP2. On 10 June 2021, which is 5 days apart, the urine sample of the accused was given to SP3 to be tested for confirmation. Based on the test and analysis by SP3, who is a government pathologist and has 7 years of experience in the field, SP3 concluded that the accused urine sample was tested positive for amphetamine. Your Honour, there was a difference between the substance of drug detected in the police urine specimen examination during preliminary screening by SP2 and the pathologist report provided in Exhibit 6, in which the police test found methamphetamine, meanwhile the report found amphetamine. This evidence shall not be admissible to the court as the results are inconsistent and unreliable based on few reasoning. So the first one is, it can be presumed that the urine sample obtained could not be the one that was analysed by SP2 and may not belong to the accused. Secondly, there are a chance of probability that the bottle may be swapped or tampered with due to the break and gap from the preliminary screening test and the pathology test, which the storing of the accused urine sample in the cabinet. Thirdly, there was no explanation given by the pathologist or any other expert to explain this discrepancy of the drugs detected in the accused urine sample. Fourthly, the test of the urine sample cannot be re-examined or reconducted as the sample had been disposed by SP3 according to the standard procedure. These are the fourth reasoning that I would like to highlight to Your Honour for today. Your Honour, You can also refer in the case of Public Prosecutor versus Datuk Haji Harun bin Haji Idris in regards to discrepancies of evidence and their credibility. I would plead to Your Honour that the court is entirely capable of accepting one portion of a witness evidence and rejecting the remainder for goods and convincing ground and rejecting the others. It is consequently vital for the courts to carefully evaluate each piece of evidence submitted by the prosecution, as they include determining the weight to be accorded to certain piece of evidence in particular circumstances to avoid misjustice to the court. Therefore, I pray to the court that the evidence of the urine sample may be expunged or inadmissible by the court, as there is a differences on the results regarding of the urine sample of the accused, which cause the evidence to be unreliable, and if the court admits the sample as evident, it may cause injustice to my client. The third issue that I raise is in regard to the break and gap in the change of evidence of the accused urine sample. After the bottle was sealed and passed to SP4, SP4 had placed the bottle in a cabinet inside his room, which he mentioned that he is the only person who have an access to the cabinet. The urine sample was stored for 5 days in the cabinet. On 10 June 2021, the urine sample of the accused was given to SP3 to be tested for confirmation. SP3 concluded that the accused urine sample was tested positive for amphetamine. The break and gap between the preliminary test and pathologists had caused the result to distinct. The differences of the results from the preliminary screening and the pathology report have raised a reasonable doubt on behalf of the defense, as there are no explanation given by the pathologist or any other expert to explain this discrepancy of the drug detected in the accused urine sample. It is not possible for a drug's results obtained to differ after 5 days of leaving the urine sample inside the cabinet. There are also no concrete proof or assurance that the cabinet is fully safe to prove that the urine sample still belong to the accused. SP4 statement cannot be relied by the court, as it is too ambiguous to believe a person without concrete or primary proof, even though the person was an investigation officer of the case. All the reasonable doubt raised is to allege that the evidence shall not be admissible to the court, as there are no concrete proof given by the prosecution to show that the sample still belong to the accused. Your Honour, you can refer to the case of Ahmad Najib Aris vs PP, which mentioned that if circumstantial evidence falls short on the level that does not satisfy the test or produce gap, it is of no use. Therefore, I would like to seek for prayers that the evidence of the urine sample shall not be admissible by the court, as it has raised a reasonable doubt about the genuineness of the urine sample, whether it still belonged to the defendants, as the accused urine sample was placed in a cabinet in the SP4 room for 5 days before the urine sample was brought to Jitra Hospital for further analysis. The gap and delays of the time to analyze the urine sample may have compromised the preservation of the urine sample, which had rebutted the prosecution part in regard of a prima facie case, as the fact is not beyond reasonable doubt. The last issue is regarding the proof that the accused had administered the dangerous drug to himself under Section 37K of the Dangerous Drug Act 1952. This is on the basis that there were no facts to show that the accused had consumed or to have administered the dangerous drug to himself. As provided in Section 37K of the Dangerous Drug Act 1952, if a dangerous drug is found in the person's urine, the person is presumed to have consumed or administered the drug to himself until the contrary is proven. I would like to argue that the legal presumptions under this provision shall not be invoked against the accused, as the prosecution had failed to show that there is a concrete proof to verify that the accused had administered the drug to himself or to have any other person to administer the drug to him, as there are loopholes to submit and rely the sole evidence based on the urine sample to convict the accused. As explained in the last issues, there are distinct results of preliminary screening examinations and pathology reports on the accused urine sample. Consequently, the evidence shall be omitted, as the prosecution would be unable to invoke the presumption under Section 37K of the Dangerous Drug Act 1952 due to insufficient evidence, lack of ground, and not beyond reasonable doubt. To support the contention, Your Honour may refer to the case of Saya Dali Reva Saya Deyaya Tola Ehta Shamia Destati vs PP, where the court held that a non-direction by a trial judge amount to a misdirection of law where making a finding on which presumption that was invoked, but by merely relying on the alternative is most undesirable. The trial judge ought to make the necessary finding, i.e. whether it was actual or presumed possession, and whether it was presumed or actual trafficking based on the evidence before her. Based on the submissions and the authorities above, I would like to affirm that the prosecution had failed to prove that this is not a prima facie case and beyond reasonable doubt. I have submitted that there are issues to be tried and before Your Honour which need to be resolved through a full trial. In the premise, I as the representative of the accused respectfully praise that the urine sample will be expunged from the evidence in this case and the accused shall be acquitted of the charge. Thank you.